Another question, which act will be applicable if the appointment order is not issued? Right? When the appointment order is not issued, then I think it is again, as I said, it will become implied contract. That's it. So it is not. It will not be in express form, but it will be in the implied form. So otherwise. Otherwise, all other acts which will be applicable to those persons for whom the appointment orders have been issued, all those acts will be applicable, equally applicable to these persons also. Only thing is, they will not be given. It is not necessary that this appointment letter should be reduced in writing and should be issued to the individual, right? So even if it is not there, then the implied contract is in existence. So all the acts which are otherwise applicable will equally be applicable to them also. I'll move on. Now, I think let us just understand the concept of employment. Again, when we say concept of employment, there will be two parties. One is employer, another one is the employee, and the relationship between them will be determined by the contract of employment. So when we say contract of employment, the general principles of the Indian Contract Act will be applicable, and this contract will give rise to mutual obligations. The employer will have certain obligations towards the employee, and the employee will have certain obligations to perform towards the company or the employer, right? And some of the terms and conditions will be contractual, and some of the terms and conditions will be non-contractual. So we will see what exactly contractual means and what exactly the non-contractual means. But the person who offers employment, he will be considered as employer, and the employee is a person who accepts the employment for a consideration. We say consideration, that is maybe CTC or the gross salary, whatever it is. So there must be some consideration, salary part. And the employee agrees for the supervision control. This is very crucial. I think we discussed this when we discussed the concept of the consultants, right? But in the case of consultants, the supervision control will not be there. It will be absent. So he will not be considered as an employee. But otherwise, for an employee, the supervision control will be there with the employer, right? So that this is the idea. So there are two parties, employer and employee, and the relationship between these two parties will be determined by the contract of employment. That contract of employment is subject to the general principles of Indian Contract Act, right? Which came into force in 1872. And that will give rise to mutual obligations, and it will be partly contractual and partly non-contractual. I'll move on. So what is contractual? What is non-contractual? When I say contractual, what I mean is the class, right? The condition will be there in the contract itself, in the appointment order itself. So this particular class emerges out of the appointment order, right? When I say non-contractual, it will not be there in the appointment order, or it need not be there in the appointment order, but it will emanate out of the operation of any other law. For example, PF, right? So you are recruiting a person, so he becomes an employee, and you are giving him 10,000 as monthly salary, right? Automatically, the Employees Provident Fund and Miscellaneous Provisions Act will be applicable to that your establishment, to that person. And you will start registering that person under PF, and you will start deduction towards PF accumulations of that person. So automatically, irrespective of whether it is getting mentioned in the appointment order or not, but because of the operation of the existing law called Employees Provident Fund and Miscellaneous Provisions Act, this will become applicable to the individual employee as well as to the establishment. So it is non-contractual. So it will not be there, or it need not be there in the contract of employment. That is what I mean by saying non-contractual.